Good morning, class. Good morning, class. Today we'll start with the legal rights and duties second slide, second lecture on it. And now we'll discuss the 10 kinds of legal rights. It is very essential to know the 10 kinds of legal rights because later on we'll be studying concepts like ownership, possession. So this clarity is required at this point of time only. We basically have 10 kinds of legal rights and duties. So the first is called perfect and imperfect rights. This being a revision class, we have already discussed all these things earlier in class in detail. So we'll quickly go through them. So insofar as perfect and imperfect rights are concerned, a perfect right is the one which corresponds to a perfect duty. And a perfect duty is the one which is not merely recognized but also enforced by law. And a duty is enforceable when an action or a suit or other legal proceedings will lie for its breach. In other words, a perfect right is enforceable in law, an imperfect right is not. But then, what is an imperfect right? So, an imperfect right is the one which, though it is otherwise legal, it cannot be enforced on account of some legal defect. Thus, claims barred by lapse of time and the claims unenforceable by action owing to the absence of some special form, such as written document, etc., are the instances of imperfect right. In all these cases, the duties and correlative rights are imperfect. No action will lie for their maintenance, yet they receive recognition from law. They remain valid for all purposes, save of enforcement. Now, all these cases of imperfect rights are exceptions to the maxim ubi jus ibi remedium. So we can take an example of, for example, time barred by law of limitation. So in the case of a debt barred by law of limitation, the debt is not rendered extinct, but merely a right of action is barred. So that lapse of time does not destroy the right, but merely reduces it from the rank of the one which is perfect to an imperfect one. Now take an example. If A has given a loan to B but cannot file a suit against B as it is time barred, and if despite of that fact B pays the amount to A, B cannot sue A and ask him to return the money on the ground that A could not have filed a suit against him to recover the debt. Now to this, Salman gives a few examples by which imperfect right may also be recognized. So, for example, number one, an imperfect right serves as a good ground for defense, though it is not a good ground for legal action. Number two, an imperfect right is sufficient to support any security given for it. For example, mortgage, pledge, though the debt for which it is given as a security has become barred by Limitation Act and thus unenforceable. Then an imperfect right may become perfect, that is, debt which has become irrecoverable by the reason of limitation might become recoverable by reason of a subsequent promise to pay the amount. That is, if uh, if the person who is the debtor, he promises to pay the amount after the expiration of the time, once again the the time limit of 3 years would start running. Now, insofar as the nature of these rights against the state are concerned, the classification, that is the classification of rights into perfect and imperfect, another problem needs to be discussed here, and that is the uh, rights of a subject against the state. In this connection, there are two views. First view, as advocated by Salman, is that a subject may claim rights against the state no less than against any other subject. He can institute proceedings against the state for the determination and recognition of those rights and claim judgment in his favor. But there can be no enforcement of that judgment. But this absence of enforceability does not amount to the absence of right. This is the case where a right is recognized but cannot be enforced. Such a right is therefore an imperfect right. However, the position in a democratic country like India is different. A citizen enjoys fundamental rights under the Constitution of India, and these rights are not only recognized by the law courts but also enforced against the state by appropriate proceeding under Article 32 and Article 226 of the Constitution. In other view advocated by Austin, it is the subject or a citizen it is that a subject or a citizen cannot have any rights against the state of which he is a member. So Austin's view is slightly different. According to him, a sovereign state claims obedience from all and owes it to none. The state would have no duties to its subject. If the state could have no duty, the subjects would have no rights. But as pointed out by Pollock and Salmon, in modern times, rights against state are recognized, and they should, at the worst, be considered as imperfect rights, as the element of enforcement may not be present in them. Then the next is propriety and personal rights. See, propriety rights are rights concerning property, corporeal or incorporeal. One often speaks of a man's propriety rights as his estate or assets or property. Thus, a man has propriety rights in his house, car, furniture, etc. Personal rights, on the other hand, are right in regard of person's status or person. Thus, the right to reputation, right to freedom of speech and expression, or right to free choice of a profession or vocation are all personal rights. Now, corresponding to personal and propriety rights are personal and propriety duties and obligations. Thus, the obligation to pay a debt or to deliver goods under a contract are proprietary obligation, whereas the obligation to take car when driving a car take care when driving a car in a crowded street is a personal obligation. Likewise, the obligation not to infringe another's copyright is a proprietary obligation, whereas the obligation not to harm another's reputation is a personal obligation. Now, basically, there are 4 points of distinction between proprietary and personal rights. Proprietary rights are valuable. That is, they can be valued in terms of money, but personal rights as such cannot be valued in terms of money. Now, the former are elements of man's wealth, and the latter are elements of man's well being. Then, the proprietary rights are inheritable, but personal rights are not inheritable. Then, proprietary rights are more permanent in nature as compared to personal rights. So, you can prepare a chart, that is, you can sum up the distinction between the two in a tabular form very easily. Now, after this, we study inheritable and uninheritable rights. Now, insofar as this part is concerned, a right is inheritable if it survives its owner and uninheritable if it dies with him. So, proprietary rights are inheritable while personal rights are uninheritable. In other words, the heirs of a proprietary owner become owners after his death, which cannot be the case of a personal right because they die with the owner. Now, estate as such ordinarily means one's belongings, one's property, whereas status means one's position in life. It is possible for a person to have a status without owning property. The popular notion of status is wealth or property. The word status also means the legal condition, as when one speaks of status of a trustee or minor or bankrupt, etc. After this, we generally study principal and accessory rights. Now, insofar as principal or accessory rights are concerned, the principal right is the main or primary right vested in a person under the law. And accessory right is a secondary right which is connected to or arises out of the principal right. Thus, the right of a person who has bought a tree is a principal right, but the right to enjoy the fruits of the tree is the accessory right, which flows from the principal right. The legal maxim accessorium sequitur principal means that accessory rights follows the principal. So if a person purchases land, he has the right not only to land, that is the principal right, but also to the title deeds, which are the accessory right to it. Now after this, we generally study positive and negative rights. So after what you have done, it is very easy for you to understand the difference between positive and negative rights. Now, according to the context which they have set, rights may also be classified as positive and negative. When a person has positive right, he is entitled to something to be done by a person who has a corresponding duty. Thus, if A has bought goods from B, the latter has a positive right to claim the purchase of money from A. On the other hand, a negative right entitles its owner to some forbearance on the part of the person who has the corresponding duty. Thus, if A has taken an apprentice in B's business and A converts, so if A has taken an apprentice in B's business and A converts covenants not to serve in a rival business for 5 years, B has a negative right to see that for 5 years. A forbears him from serving in the rival business. So that is how you need to construe. So basically, we can say that there are seven rights, seven differences between negative and positive right. So a positive right, it corresponds to positive duty. Negative right corresponds to negative duty. The content of positive right is a positive act. The content of negative right is forbearance or not doing something. Then positive right entitles an owner to an alteration of the present position to his advantage. Negative right, whereas it maintains the present position of the things. Now, positive right aim at a positive. The aim is a positive benefit. In negative right, aim is not to be harmed. Insofar as positive right is concerned, it is a right to receive something more than one already has. And insofar as negative right is concerned, it is a right to retain what one already has. So positive right requires the active assistance of other persons, whereas negative right requires only passive acquiescence of others. And positive right has mediate and indirect relation to the object, whereas negative right has immediate relation to another. So after this, we go ahead with the difference between legal and equitable rights. Now, insofar as legal rights are concerned, they are those which are recognized by the court of common law. Equitable rights, which are also called equities, are those which were recognized by a court of chancellery. Now, the Judicature Act 1873 did not abolish either law or equity, but made them consistent with each other by abolishing those rules of common law which conflicted with the rules of equity. But they differ when it comes to two respects. First is in the method of their creation and disposition. See, the method of the creation and disposition are different. A legal mortgage of land must be created by deed, but an equitable mortgage can be created by mere deposit of title deeds. Now, insofar as the efficacy part is concerned, so legal rights are more efficacious than equitable rights. Equitable rights have a more precarious existence than legal rights. There are two inconsistent legal rights claimed adversely by different persons over something or same thing, the first in the time prevails. The similar rule applies to the competition of two inconsistent equitable rights. But when a legal and an equitable right conflict, the legal right will prevail over equitable, even though it is subsequent to the origin, provided that the owner of the legal right acquired it for value and without notice of the prior equity. Which means legal rights are in all respects superior to and more efficacious to equitable right. Now, insofar as the recognition of legal and equitable rights in India is concerned, in England, estates are either legal and equitable. Thus, in England, the mortgagee's right to redeem as regarded as a, is regarded as a creation of courts of equity and is an equitable right known as equity of redemption. This is not the case in India. So it has been decided in many cases. There's one case, Tagore versus Tagore, which is a landmark judgment here. Then there are other cases also. For example, the Chatra Kumari Devi versus Mohan Vikram. In that case, the Privy Council endorsed the view taken in the two previous cases of Tagore versus Tagore, and one more case, Webb versus Macpherson, and observed that the Indian law does not recognize legal and equitable estates. By the law, therefore, there can be but one owner, and where the property is vested in a trustee, the owner must, therefore, lordship's things must be a trustee. This is the view embodied in Indian Trust Act also. So you can see section 55 and 56, the right of the beneficiary being in a proper case to call upon to convey to him. Now after this, we would go through another set of rights, and that is real and personal rights. Now see, insofar as the real and personal rights are concerned, a real right corresponds to a duty imposed upon a person in general, and a personal rights correspond to a duty imposed upon determinate individuals. So a real right is available against the world at large, and a personal right is available only against particular persons. Thus, access right not to be assaulted or defamed is available against the whole world, but access right to proceed against his assailant or defamer is personal, being against the person individually. So real rights, however, are more valuable and advantageous than personal rights. Real rights are mostly negative, whereas the personal rights are mostly positive. After this, you have rights in rem and rights in personal. This is also what you have already done in torts. So a right in rem is the one which is available against the whole world, and a right in personam is the one which is available against a particular set of individuals only. So in personal rights, it is the personal relation that is the predominant factor, and therefore such rights are called jus in personam. Now a right in rem as such is a right vested in some determinate persons, so either personally or as a member of community, and available against the world at large. Thus access right not to be defamed or assaulted are rights available against the whole world. Such rights are called rights in rem. Their number is countless. Thus, the right to freedom of person, ownership and possession of the property, the right to reputation, the right to copyright trademarks, they are all instances of rights in rem. But the very opposite of right to rem is the right to personam. So, a right in personam is a right available only against some determinate person or body, and in which the community at large has no concern. So if X agrees to sell his house to Y for a certain sum, X does not carry out the contract, Y will thereupon have a right to sue X for damages of breach of contract. Here, the mutual right of X and Y are created by their private mutual agreement. These rights are personal to both the parties. So third parties are not concerned with them. Such rights are therefore called rights in personam, that is personal rights, as opposed to the general rights. Now see, generally speaking, rights in rem are negative rights, whereas rights in personam are positive rights. So thus a right to debt or a right to delivery of goods are rights which are positive as well as in personam. On the other hand, the right to reputation or right to freedom of person are rights which are negative as well as in rem. However, this is only a general rule, and some negative rights are also rights in personal. Thus, the right of an employer to ensure that the employee does not work with a rival employer is a right in personam, which is at the same time a negative right. After this, we go through the rights jus in re propria and jus in re aliena. Now, see, try to understand the most absolute power which the law gives over a thing is called the right to property, that is dominion. This is the real right of a thing which is one's own. So, it being one's own, it is called jus re, jus in re propria. But a man may have a right to property less than full ownership or the dominion, being in fact vested in another. So these rights are called jus in re or jus rights in re aliena. So both can be created in respect of same property. A right in aliena is one which limits or derogates from some more general right belonging to some other person in respect of the same subject matter. All these rights which are not thus limited are jura in re propria. Now, if we take an example, X mortgages his house to Y and gives him possession thereof. X thereby creates an encumbrance by dividing this property right in the house and Y, of which Y becomes the temporary occupier. However, X still has a right to redeem the mortgage. This right, which is for the time being detached from X's complete ownership of the house, is called in re propria. In re alienum. After that, we come to the last thing, and that is servient and dominant. See, a right which is subject to an encumbrance may be designed as servient, while the encumbrance from which derogates from his may be called as dominant. So, a land for the beneficial enjoyment of which the right exists is called dominant heritage, and the owner or occupier thereof is the dominant owner, and the land on which the liability is imposed is called the servient heritage, and the owner or occupier is called the servient owner. Thus, A is the owner of a house. A, who is the owner of the house, has a right to weigh over the neighbor's B line, or has the right to maintaining eaves for discharge of water from the roof of B's land. So A's house is dominant heritage, and A is the dominant owner, and B, his house is called servient heritage, and B is the servient owner. So with this, we end this particular lecture. If you have any, if you need clarity on any point, please do get back to me. Thank you.